Mr. Chairman, honorable members, listened to the questions submitted on by our learned friends, the attorneys for the accused persons, and we are opposed to their prayer that these questions are fit for reference to the Constitutional Court. Mr. Chairman and honorable members, in their submissions, they did not address you on the manner of making a reference to the Constitutional Court. This is a matter that is provided for by the Constitutional Court, Petitions and References Rules 2005. In those rules, Rule 18 prescribes the manner of making reference to that court. It provides that where reference to the court regarding any question as to the interpretation of the Constitution under Article 137, Clause 5 of the Constitution is to be made, the original court, and the original court is defined in the rules to mean the trial court, like this one, shall submit the reference in terms of Form 2 of the schedule to these regulations, stating the specific questions or issues to be answered or resolved by the court. Mr. Chairman and members, the Form 2 of the reference in paragraph 1 requires that this court is of opinion that a substantial question of law as to the interpretation of the Constitution has arisen in the proceedings. So it is not true, as stated by Senior Counsel Mr. Kwago, that court's hands are tied. It's court to form an opinion, therefore it has a discretion to determine whether indeed it is convinced that matters that require constitutional interpretation have arisen in these proceedings. We shall approach the issues raised, and our take is to begin with issue number 3 regarding the impartiality of this court. Note that on the 13th January 25, names of members of this court were requested and read to the accused. They were asked and had no objection to any member, and that was in pursuance to the regulations. In that regard, we would say that an issue of impartiality does not arise in these proceedings because the accused have not objected to any member. On this same provision, Regulation 49 of the UPDF Rules of Procedure Regulations requires the opinion of each member as a way of handing down verdicts. So a challenge to the impartiality of court should go to the opinion holder, and these names were disclosed. That would be the approach. And this is also the approach in civil courts. I'm glad Honorable Martha Karua told us she has been a judicial officer. I know that the principles of civil court, where you request the judicial officer to excuse themselves. Regarding issue number 1, it deals with whether the offense under offenses relating to security, section 128, F of the UPDF Act defines the offense. Mr. Kalibara said that it does not define the offense, together with Mr. Banga, and their view is that because it says a person who omits or does an act. When you cross-reference with other laws, an offense can be constituted by an omission, can also be constituted by an act. Even in the penal code, an unlawful act or an unlawful omission can constitute an offense. There is also a requirement in the offense that the intent must be to prejudice the spirit of the defense process. Those are matters once alleged that are supposed to be subject of evidence, and the burden is on the state. But at the moment, this issue is premature. It is determined with evidence, and this court can decide that matter. There is also an issue regarding whether the trial of civilians in general court martial is consistent with decisions of civil courts in earlier cases. And one of the cases cited is the case of Honorable Michael Kauzibuka versus the Attorney General. Most other cases cited, including retired Captain Amon Bialugara and Semuju Abduminana, were referring to that decision of the Constitutional Court. But the decision is pending before the Supreme Court, and the orders and declarations made in that decision were stayed. So it would not be an authority that determines the position. It would rely on earlier authorities. The earlier authorities included the case of Hadija Namukero versus Attorney General, Civil Act number 4/2012, where they said the provisions of section 119, which is now 117 of the UPDF Act, is proper, and charges can be maintained under that provision. There's also an issue number 7, whether the General Court Martial has jurisdiction to deal with cases under the Firearms Act. The UPDF Act defines a service offense to include offenses under the Act and those under any other act for the time being in force committed by a person very subject to military law. And the Supreme Court has pronounced on this in Attorney General versus Uganda Law Society. Page 10, and in that case, it was a unanimous decision of the Supreme Court arising from the constitutional appeal. They only required that for an offence under an act other than the UPDF Act to be within the jurisdiction of the General Court Martial, it must have been committed by a person subject to military law. And what they required was to allege and show that the accused persons committed either of the two offences while they were subject to military law. That is the link they required. And the applicants have not shown that that link is not in the charge sheet. And it is the burden on them to show that there is no link. It is not a link that these people were subject to military law. We also wish to point out that there are procedural safeguards for the trial of persons before the court, including presumption of innocence, burden of proof, and these are matters for a trial court. These are not matters that require constitutional interpretation. That I hand over to my colleagues to continue.
I would like to back up the submissions of my captain members. I'll begin by quoting Article 132, Clause 4 of the Constitution. It says that the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. But the Supreme Court has severally decided that these courts have jurisdiction to try the accused persons. And my colleagues on the other side repeatedly citing the decisions of the Constitutional Court will be in contravention of that specific article. And then I will reply to the other general issues, specifically Regulation 63, Regulation 2, and Regulation 69. Well, Chairman, the General Court Martial operates under a framework of the UPDF Act, which ensures its independence. The Act provides a clear separation between the administrative functions of the High Command and the judicial functions of the General Court Martial. But I refer you to section 14 of the EPDF Act, Cap 330, and section 195, so it establishes the General Court Martial. While the High Command may oversee the General Military Administration, it does not interfere with the judicial making process of the General Court Martial. Members of this court, including its chairman, are carefully selected and sworn to administer justice so that fear or prejudice. Now, this is under Regulation 14 of the Uganda People's Defense Forces Regulations. They are guided by the principles of fairness and impartiality enshrined in the Constitution, Article 28, and the EPDF Act. The presence of the legal officers and adherence to established legal procedures further guarantees impartiality of the proceedings. This court has autonomy in its decision-making process. It conducts trials based on evidence, law, and legal principles, not directives from the High Command. And the decisions rendered, furthermore, the decisions rendered are subject to appeal and review by superior courts. By superior courts, I mean the Court Martial Appeal Court. This is provided under section 225 of the APDF Act. The relationship between the GCM and the High Command is administrative, not judicial. The High Command's involvement ensures logistical and institutional support for the court martial, but does not extend to influencing judicial outcomes. Now, concerning Regulation 63, Regulation 2, it is very clear the role of the judge advocate is to advise court on matters law. If the court disagrees with the decision, they shall record in the proceedings in its reasons. It does not mean that they are entirely binding, as one of the colleagues on the other side alluded to. My Lord, I give way to my other colleague to submit. That is all.
Chairman, board members, I will straight away go to the question that was framed by my colleagues, especially question 6, the arrest, rendition, and trial of formerly two accused persons that is can be Kizza Besigye and Hajji Obed Lutale. Chairman and honorable court members, the ruling that was rendered by this court today morning settled that. And in that ruling, the court clearly pronounced itself in as far as the arrangement that is between the two countries, that is Kenya and Uganda. And my chairman, that arrangement is backed by the law. It's backed by the East African Community Treaty, of which Uganda is a party. Not only being a party, it also domesticated that treaty. And the same thing, the domestication was done by our neighbors, that is Kenya, also domesticated that treaty. So, my chairman, under that treaty, specifically under Article 124, that addresses the protocol of peace, on peace and security. And the article outlines the commitment of partner states cooperate on issues related to peace and security. And my chairman to motion, put into practice that cooperation. That's when we see the coming up of that memorandum of understanding. For the two states cooperate on matters relating to security and cross-border crimes. Therefore, we also refer to support the authority that my brother and senior colleague, Councillor Kwago, alluded to, the one of Amar, Awad, Umar, and 10 others. And my own chairman, that's a very good authority, because it clearly highlights the role of states that are parties to the East African Community Treaty. And if I may, on page 70, page 71 of that judgment, my chairman, under paragraph 30, if I may read verbatim, states that we also observe that the East African Community Treaty was instigated in Kenya, Tanzania, and Uganda. Uganda Parliament enacted the East African Community Treaty Act of 2002 by virtue of statutory instrument number 29 of 2005. The East African Community Act Amendment Instrument 2005. It came into force but the argument I'm making is that there exists an arrangement between the two states, the two partner states, that is Kenya and Uganda. This one was confirmed by authority that was clearly and well cited by my senior colleague, though with blood interpretation from his side. But be as it may, my chairman and honorable court members, we submit that indeed the laws were followed. In other words, in the absence of the extradition treaty between Uganda and Kenya, this law applied squarely on both countries. My chairman also, and that one would not really need a reference to the plate, otherwise it would be a waste of time. My chairman, on the other issue, which issue 2, and my senior colleague earlier alluded to it and submitted on it, but maybe to add something that is maybe important. But we reiterate all the authorities that we have provided to us by colleagues. And two things are cut across in all those authorities. And my colleague also talked about it. There is a recent ruling. This one you may not need to refer to the Constitutional Court. And that ruling was very clear, staying the execution of the Kabazibuka case findings. It is as plain as that. You don't need to refer to court that interpret this or try to civilians. It will be absurd, very absurd. And my chairman, further on that, we also confirmed that indeed the decision, the authority that was cited by Steel Council Okwago, the one of Abdul Semuju, aka Nan, the issues that had been raised in Kabazibuka case were the same issues that were raised in Nan, and he can testify and so my chairman, it would be the feat of justice. And not only that, but also wasting court's time. To now also apply to stay the execution of Menana. Though there has been an appeal, we are aware, and the Council of Power is also aware that there has been an appeal against the decision of the Constitutional Court. We are yet to know the hearing dates. But, my chairman, we submit that we base the trial of civilians in this court on the decision, or the ruling, staying execution, the decision of Kabazibuka. And therefore, in this matter, Nana cannot really suffice. As I conclude, my chairman and our court members, I would also like to add something on the question of impartiality that my colleague talked about. Whether the General Court Martial can be impartial when adjudicating the matters before it, and the reference was made to 28.1. My chairman, my colleague addressed that, but to add something, under section 207 of the APDF Act, where rules of procedure and evidence that apply to civil courts can as well be applied to General Court Martial. That is in the law. And my chairman, that goes back to the supremacy of the Constitution. Under that Constitution, it provides clearly two things: the impartiality of courts. So it's out of that law that is now 207, it applies to General Court Martial. So what my colleague said, and that article under 128.1 of the Constitution and 2. So impartiality really it is there. This court is impartial. And my chairman, lastly, I wish to also add on what my colleague said, and that is on the procedure, on how you refer a question for interpretation to the Constitutional Court. Well, Chairman, that one was settled by a Constitutional Court Ismail Oselko against Kampala City Council. And Justice Wambu's then was very clear, extremely clear. Where he stated that the petition, you can just that with the necessary modification, reference must show on the face of it that interpretation of a provision of the Constitution is required. But Chairman, what we saw today in the framing of questions was an appeal in disguise. An appeal in disguise. The questions, the way they are framed, we would actually say that counsel for the accused persons would go under the Martial Appeal Court rules through the appeal against the ruling that was rendered today morning. Other than casting a net, but let us see what comes out of the lake. The court does not operate like that, Madam Chairman, and I pray that you should not allow that to happen in this court. And Madam Chairman, that was also emphasized recently by a Constitutional Court Reference number 31 of 2010. That is Uganda against Francis Atugonza. And court stated that constitutional reference by the court that is determining the cause or a party to the proceedings will request the court, and this goes back to what my colleague and senior Counsel Kalibara stated, that the court, so the hands of court are tied, quite absurd. They are not. That's why you're here. Your Chairman, that statement itself, it simply puts a constitutional court into a position of applicability of the law, of the rules, which I disagree with my colleague. The constitutional court can apply the law in other instances, but as far as constitutional reference is concerned, it's basically interpretation, not applicability. Not applicability. Applicability is with the authority of court. Now, whether the court, I'm not saying this court, whether the court, any court, applies the law eventually, that is a different matter. And there are channels. You appeal. You appeal. That's what he told me. Now, and lastly, my Chairman, we pray that unless the law has changed. But, my Chairman, lastly, we pray that from my side, because my senior colleague is going to give it a final push, we pray that you really be pleased with us on the law, and especially where you are satisfied with the decision, with the ruling of court, where you are supposed to go. So, and my colleague, my senior colleague is going to bring this forward.
Chairman, court members, I associate myself with my young brothers, and I have something to add. In regard to impartiality, when you look at Article 142, appointment of judicial officers, paragraph 1, the Chief Justice, the Deputy Chief Justice, the Principal Judge, the Justice of Supreme Court, Justice of Appeal
appeal and a judge of High Court shall be appointed by the President acting on advice of Judicial Service Commission and with approval of Parliament. Now, our colleague tried to dramatize that here you are a judge, you are a complainer, you are so you cannot get a fair trial before this one. The same person who appoints these justices and judges is the same person when you look at the section 194 of the opinion. The same person that appointed the board members, the instrument which you read to the opposing person, that is the commander-in-chief, is the president, and it is the same person. So where is impartiality in that regard? So that one does not require any constitutional interpretation. Section 208 was also attacked of the UPDF Act. I want to draw you to look at section 4 of the Penal Code. Section 4 of the Penal Code Act is about the extent of jurisdiction of courts, and it states the jurisdiction of the courts of Uganda for purposes of this code extends to every place within Uganda. Notwithstanding subsection 1, the courts of Uganda shall have jurisdiction to try offences created under Section 23, 24, 25, and 26 committed outside Uganda by Uganda citizens or person ordinarily resident in Uganda. For avoidance of doubt, the offences referred to in subsection committed outside Uganda by Uganda citizens or a person ordinarily resident in Uganda shall be dealt with as if they had been committed in Uganda. And those, under those sections, those offences are treason and aiding military to police officers, that kind of offences. And now when you go to section 3 of Anti-Terrorism Act, Section 3 of Anti-Terrorism Act, the royal jurisdiction of courts of Uganda in relation to offences under the Act. The courts of Uganda shall have jurisdiction to try any offence prescribed in this Act, where committed, if the offence is committed in Uganda or outside Uganda. So, it's, the section puts down all circumstances under which the offence can be committed. The offences committed outside Uganda, to which this section applies, shall be dealt with as if committed in Uganda. So, this section is almost the same wording as section 208 of the should be the fact. Where these officers are asking, where do we get jurisdiction to try an offense which was committed in Kenya? So it is right. It's not what is special about this. It's not the news. What should be interpreted by the Constitutional Court. So jurisdiction extends outside Uganda according to the statute. And we earlier stated that jurisdiction is the creature of statute. Therefore, there is no need for such a section to be referred to the Constitutional Court for interpretation. What would you interpret? My Lord Chairman and all court members, we do believe that our land colleagues are aware. They are citing Kawasuluka case, but they are aware that that case, if you are to implement it, there must be execution. You go and extract the execution order. And if you get that order, we would not, this honorable court would be, it cannot proceed in a trying the civilians. Even execution order. And you know how to get execution order. If you don't know, then you need to go and advise how you are going to proceed. So, it would be frustrating the highest court of the land and read verbally how they in the result, we allow application and make the following orders. Execution of and or giving effect to the orders and declarations issued by the Constitutional Court and Constitutional Petition number 45 of 2016 between the parties hereto are stayed until disposal of applicants intended appear. Who are you to go against the order of the Supreme Court? Chairman and all of members, that is the position of the law. And if in a case it is not, if we go to accept, personally I think I would even be prosecuted to give a reason that they do not have jurisdiction. Chairman and all of members, until otherwise, as of now, we have jurisdiction of one of the states. So there is no matter that we refer again for constitutional.
Thank you so much.
The fact I think the issue of Kizza error. The issue of Kizza error. First of all, it did not arise from the ruling of this court this morning. This was a different matter. Court never made the rulings in regard to Kizza error, and court determined, pronounced itself, and it is part of sufficient. So there is no way out of this court and again turn on the same point of law to interpret what happened in that ruling.
What I learned for the record, and in rejoinder, I'll be brief. The beauty about attending class is that some learn and some do not learn, even when you attend it. Council Kalibala, Council Ganga, Council Kalua, and Council Lukwago went into further detail
about the constitutional provisions, the questions vis-a-vis the UPDF Act and the Constitution. I am disappointed that they did not get a financial benefit to that, but they offered it free of charge for us all to hear and listen. The actual fact that we sit here and says that does not raise a question, that is a question, is the actual reason as to why we should be in the Constitutional Court on such matters pertinent to this matter. I also want to state in general rejoinder that it's not the duty of the prosecution to frame questions that we want the Constitutional Court to address. And nor is it the duty of this Honorable Court, with all due respect, to usurp powers of the Constitutional Court under 137 to interpret questions posed by the parties. I also want to state unequivocally that there are two legs within the Constitutional Court. If it may please you, I will substantiate on the two legs. On the two legs, there is one where the court deems it fit to raise a constitutional question. That is one leg. And in the wording of the Constitution, they use the word may. I believe that you as officers of the UPDF understand command, order, and all that. The second leg of that Constitution, Article 137, 5B, gives latitude to the parties to escape the tyranny of a court, tribunal, or a disciplinary committee by allowing the parties to pose a constitutional question. And we didn't move under the other leg one. We used leg two to protect and defend the rights of the accused person. And that leg, in the Constitution, it says shall. It is coiled in mandatory terms. The Supreme Court has been in position to guide in a number of authorities about the coiling of the Constitution and the word shall and may. And the framers of the Constitution, of which Dr. Besigye, one of the accused person was, is very clear and instructive. So it's our duty to ask that the professional UPDF under Article 208, the profession and professional soldiers should respect the command and the supremacy of the Constitution, of which we are all here to defend. Members of the General Court Martial, I also want to mention that when the prosecution wants to phrase its own questions, it shall present them before the Constitutional Court. We have framed ours, and we are saying this matter warrants a constitutional interpretation. Members of the tribunal, I do not understand the obsession with the Kabazukura case. My senior has already alluded. I said the General Court Martial, Tribunal, or any disciplinary committee. And with the word court, if it appeases your ears, I shall maintain that. Professionalism means respect to the rule of law. None of you will be hurt, for there is nothing for you to lose if you refer our questions to the Constitutional Court. And in the way, counsel lied to this Honorable Court by saying that these courtesans are not tied. Actually, they are tied with chain and shackles. And I'll address in broader perspective about the MOU you talked about. That MOU is alien to us, and it's not anywhere within our knowledge. All that we are so sure of, Article 79 of the Constitution only gives powers to Parliament to make laws, and also has a condition that no one else can make laws that have force in Uganda. Whoever that MOU might have had his own wishful desires, and that's not our problem. Our problem is that the law of the land must be enforced the way it is to the latter. And also, in the most severe I want the court to take judicial notice under the Evidence Act, as taught by Senior Karibala, that even in the most cases of Jamil Mukulu, there was an extradition from Tanzania. As to whether the accused person did not enjoy that benefit is also another phenomenon we are about to explore. I also want to state that the issue of impartiality has been largely misunderstood by my colleagues. It's not about the members of the court, no. It's about structural issues rooted in the UPDF Act vis-a-vis the Constitution of the Republic of Uganda. We do not have any desire to impute the credibility of the members of the panel, and we have less appetite for that detail. I also want to state that, having said so, these are our questions as to whether they desire to make submissions challenging any of the interpretation. Unfortunately, none is qualified. None of us is qualified to authoritatively do that, save from the Constitutional Court. And trying to do that is violating and usurping the powers of the Constitutional Court and molesting and defiling the Constitution of this Republic. The idea that we court covers Guruka and leave other cases that have been decided and not appealed is appalling, and should be the duty of the officers of the UPDF to maintain the stature or the desire for the UPDF to be a professional army. And finally, when a matter arises, when a constitutional matter arises, it has to be referred for interpretation. Otherwise, again I state, none of us is qualified to interpret the Constitution. And another rider is failure to respect the interpretation of the Supreme Court, also tantamount to violation, molesting, raping, defiling, and abrogation of the Constitution of the Republic of Uganda. It's our desire that we do not want the UPDF and its institutions, most especially the General Court Martial, to trade and trend that way. Again, we do not know about that MOU being quoted. We do not know it as under the laws of Uganda. We are certain that it did not conform to Article 91 of the Constitution of the Republic of Uganda, and whoever made it can as good as use it to light a fire and a charcoal stove for their own benefit. Thank you so much.
Honorable Chair, panelists, and members of the judge. This court, I want also to take this latitude to add on my voice as the defense team for Dr. Kizza Besigye and Dr. It is quite very paradoxical but various for prosecution to allege or to assume jurisdiction that this court has jurisdiction interpretation which raised. We have to take the confidence of the fact that the Constitution of the Republic of Uganda ushered in this controversial to be able to handle cases regarding the discipline of the. It is not true that because by virtue of that very enabling provision of the Constitution that you have jurisdiction in that institution. I would have to implore this court to adopt this decision. Why the Constitutional Court was faced with the same similar matter in the case of Honorable Omusango case which we had prior to the morning while submitting the same was submitted by the defense team. that is by the House of Lords in this case, while elucidating on these facts, we are able to persuasively adopt the decision in the Namibian case of State versus Kizza 1991, volume 20 SA, at page 813, and it was to the effect that the Constitution is the national act. The Constitution of a nation is not simply a statute, which mechanically defines the structures of the government and the relationship of the government and the governed. Those are the few catching words. It is a mirror of reflection. When you go to a mirror and you put in front of you, you can able see what is happening. So this is a mirror of reflection, reflecting the national soul of the identification and the ideas and the aspirations of a nation, the articulation of the values bounding its people and disciplining its government. In summary, therefore, as I invite this honorable court to adopt, and they should respectively adopt these decisions. These decisions act as jurisprudence. They are binding precedents. This is a decision from the Constitutional Court. This is what the House of Lords had to say, that in interpreting the Constitution, that's why I'm differing from the view of my land friends. They are trying to hold away and mislead this honorable court, which we totally disregard. That in interpreting the Constitution, the rule of harmony and completeness requires that constitutional provisions should not be looked in isolation, but rather the Constitution should be looked as a whole document. That's why it is because of the Constitution is referred to as the Grand Law. Article 2 of the Constitution is very clear. If any law is inconsistent, is repugnant, any regulation, including the one which this General Court Martial is citing, if it is inconsistent, it is contrary to the provisions of Article 2. The framers and the promulgation of that article were alive to the fact that certain issues arising out of during proceedings like similar one might arise. That if any law, if any regulation which is in consistency with that very particular article, it should be declared now. And it is because of that very same article that we are trying to invoke Article 137 to enable us to refer this matter for reference. So it is misleading and it is quite very paradoxical. I humbly request that this honorable court will disassociate the submission of the prosecution. They have miserably failed at any step with any item of evidence to prove their case as open.
Because in my view, they have not dealt with any of the issues. I'm grateful that they are doing their work. We are past the stage in this country where we should have mechanical responses to many issues. Just say no because I can say no. I think I should say no because it is value the position that I have adopted. I have listened carefully to what my land friends have said, and a lot of it sounds to me like the arguments we will invite them to make when we go off, when we are referred to the Constitution. Because those arguments will be very important in that court as it interprets the articles that we have cited. Honorable Chair, we did say in our submissions initially that the questions
around impartiality have nothing to do with the 5 members who are in this court. It's not personal. We have no doubt that the gentlemen or lady officers who are in this court are fine. But the regulations recited, they are laws, they are not individuals. I appreciate fully the idea that the High Command and the General Marshal have different roles in the street. And when the rule which says that the High Command can be consulted on matters of law, I haven't heard in 69, I haven't heard the response that says it can't. If we take it to the other side where we are used to appear, there is no similar provision where a judicial officer, also appointed by the president, can consult the appointing authority. It doesn't sit comfortably with the idea of language. So it's an institutional issue, it's not a personal issue. It has nothing to do with the gentleman before whom and the ladies before whom these proceedings. Honorable Chair and honorable members, we treasure the Constitution, as I am sure that you do. Because it is the only one that equalizes all of us. Only one. Where everybody can look and say, I am equal to this one, in that document. So we find it uncomfortable when some of these things are trivialized, especially where they have to do with the Constitution. This is not a petition that we are asking made, this is a reference. There is a reason why we have a difference between petitions and references. And what I honestly expected my land friends to do was to enrich the questions so that we go together and come back together better enriched, knowing where everybody can trade, so that we are not putting eggshell, nobody is walking on glass, nobody is. That's what I expected. That they would come and say, the phraseology is not proper. Honorable Chair, this is a better phraseology. Because that appears to us to be what must have been Article 137.5 B is invoked. So I would invite the Honorable Court to consider those questions as posed, and perhaps to also just put another small matter to rest. The question of how you refer. There has been reference made to rules on petitions and references. That is the stage we will get to when the reference is being made, because it is a formal document. It will be presumptuous of us to phrase the questions and then just trust them in the face of the court. We would have been hoping that we would have agreed together with our young friends so that we focus on what the court will submit. The questions that we posed were our proposals. We thought they covered the necessary ground. My brothers on the other side can enrich them. In fact, I invite them to do so. So that when they are leaving the court, we are in agreement about what those questions are. We are not debating at all the power of the appointing authority. The appointing authority appoints many people. But if an ambassador were appointed and is given, allowed to exercise judicial power, we would argue the same things. Although they were appointed by the same. If an RDC attempted to exercise judicial power, are also appointed by, we would argue the same things. We are just dealing with matters of rules. They affect all of us. They are for the benefit of all of us. Today, tomorrow, in the future. So we shouldn't deal with them lightly. They are serious. Lastly, my learned friend Raphael knows that constitutional interpretation is a matter in realm. It's not in persona. It is in realm. Once the court says A, it has said A. Only a superior court can unsay A. We have cited before you a number of authorities where the court which interprets it has consistently, in fact in one of the cases, they just said we adopt the other views of the transplant. Consistent. There is no other interpretation. We have one. Only one. We must abide. If indeed we are subordinate to civilian authority, we must abide until there is another interpretation. So there is no stay for Semonju, there is no stay for Captain Yarugaba. I'm not sure why. The Bangalore Society that was referred to was confirmed. The position is clear. And I invite you very respectfully to appreciate that position and to do the right thing. To send us where we can settle these questions. They will benefit us here in this case, they will benefit other cases, they will benefit in the future. We will have to learn. This is about all of us. Every one of us in this room, every one of us must go home comfortable in the knowledge that we know what the law says. Because again, in this jurisdiction, there is only one person who cannot be subjected to these types of processes. Only the city head of state. Everybody else. Everybody else, without exception. I thank you, Honorable Chair. My land friend wants to close.
Thank you, Chair. Briefly, the issue of Kizza did not arise in the basic proceedings. It's later here, not there. Chair and the members, the constitutional reference is not only about today's rule. It's about the proceedings right from the beginning. Right from the very moment charges were read before them, and also the rulings that were made that you have jurisdiction. It's a whole package. So it's misconstruing the context of this petition, rather requesting for a reference, all the proceedings you have had. So it cuts across. The other thing is about the East African Treaty, the MOU. He made some submission here which is really disturbing.
that your ruling is settled it all, that is final. You are the Alpha and Omega on interpretation of the Constitution. Is this an appellate court? That is not really the position of the law. We take exception to that, some previous. And it's not also an appeal to the court martial appeal court that this is an attempt to appeal. No. It's very clear, grounded under the constitutional provisions. On the question of the Supreme Court, he said there are decisions of the Supreme Court, the order of state specifically in Kabasuburuka. I want to address you on this. 5th of August 2021. And the decisions we made reference to of Semuju and Amoni Byarugaba reaffirming the Kabasuburuka position of 2020. So this order is not applicable. And I want us to put it in context, Mr. Chairman. I have a copy here. They are consequential orders that were given. That all files pending before the General Court Martial be transferred to the civil courts. That was the consequential order which was stayed, not the interpretation. And it's the reason he advanced the argument that a decision of the Constitutional Court is in rem, is not in persona. So the consequential order is the one that was stayed. But the Constitutional Court has been consistent that the interpretation about the jurisdiction has not been overturned. If anything, it has been reinforced by the recent Supreme Court decision in the case of Ogwang versus Uganda. If I may just read one aspect of it, it's very, very important and instructive, Mr. Chairman, so that it's the only Supreme Court decision we have, the only one on this. And no misconstruction should be made to say that the Supreme Court has got any other order as far as the jurisdiction is concerned. As we are getting it for me, allow me also refer you to the submission on the applicability of the Firearms Act. Mr. Chairman and the honorable members, the Semuju case is very, very clear. It's very, very clear. The General Court Martial's jurisdiction is only limited to trying service offences specified under the UPDF Act, only in respect to persons subject to military law. Offences under the UPDF Act. Military law under the UPDF Act must be construed to exclude laws that are the preserve of civil courts. This has not been set aside. This has not been subjected to any other interpretation. So where do they derive that argument that this honorable court is clothed with jurisdiction to handle matters under the Firearms Act? So the East African Treaty, I want to talk about the MOU and the East African Treaty. They were again misinterpreting this decision of Omar Awad. Omar Awad, the extract they were making, the extract they made is very clear. They were talking about repatriation of fugitive offenders. And when you look at the Extradition Act, the fugitive offender is defined. A person having committed an offense, you run away from the jurisdiction. And again, in this particular case, you will find the facts, you read the facts. In Tanzania, for example, where these people were repatriated from, there were extradition proceedings, only that they did not wait for their appeal. So, this East African Treaty did not in any way purport to outlaw the Extradition Act, or in any way to repeal it. Let me use that word. The treaty did not repeal the Extradition Act, it is still good law, and it must be complied with. So, an MOU made under the treaty, which is also subject to question because we have not seen it, cannot be said to be within the parameters of the extradition law. Now, to emphasize the other point, Mr. Chairman, I want to just read that extract from Ogwang. In our view, the body of the UPDF Act specifically sets out the army courts as a parallel judicial framework, distinct and juxtaposed against the courts of judicature. It appears to have been contemplated that the UPDF courts were better placed to address the discipline issues within the rank and file of the armed soldiers, and better able to handle out penal sanctions, that hopefully deter further offending. It is through these structures that UPDF soldiers are made accountable. And they concluded by indicating that the Constitution of the Republic of Uganda, which gives Parliament authority to make such laws, as provided for under the relevant provisions, deemed it necessary to create a disciplinary court. They emphasize a disciplinary court for the members, the rank and file of the UPDF and members of the UPDF. So this reinforces the position given by the Constitutional Court that the jurisdiction of this honorable court is restricted to those matters which are within the UPDF Act and not any other law. That is the latest decision in Obama. Now, finally, the issue of the procedure. Mr. Chairman, this issue of procedure, the procedure to follow here is very, very clear. Once you move court for the reference, the questions are raised. They are framed. The questions are framed. So we are at a stage of raising these matters for purposes of framing the questions. And this is important. So I don't know how else they wanted this to be done. And this has been the practice all through, that you raise the questions, you raise issues, and then the questions are framed. So they can't fault us on the procedure we have adopted. Allow me to invite the Council Friend to add one to submissions, then we wrap it up.
Thank you, Mr. Chairman. Mr. Chairman, the quick, because it's been a long day. First, that my colleague, Arno Raphael, I hope that's the correct one, did make reference to similar provisions in the penal code and the acts regarding terrorism. I just wish to remind him, Mr. Chairman, that none of the offences from the charge sheet and the amended charge sheet for that matter are brought under the penal code or the act regarding terrorism. So that attempt to juxtapose the two cannot really hold it. The other one, we did refer to the appointment of the lady and gentlemen officers of this court, and saying that they are also appointed by the Fountain of Honor. It is correct. Just to remind the court that when the judges and justices are being appointed, because they do perform a function of determining rights and obligations, including determining whether someone should leave or not, there is an extended process which starts right from running adverts in the newspapers, whereby the public participates. Mr. Chairman, we are not aware of any such similar process of an advert regarding the membership of the court martial. We are also not aware that the most junior and least officer of the Uganda Defense Forces perhaps engages in the process that appointed the ladies and gentlemen officers before us. We want to assume that that is at the pleasure of the Fountain of Honor, perhaps in communion with the members of the High Command. And that is why, as my land friend alluded to, that Regulation 69 envisaged the good manners that you revert to your appointing officers. The challenge there is, Mr. Chairman, is that it wouldn't be about the budgeting or the logistics, as our friend tried to say. It actually says you refer to a point of law. Mr. Chairman, matters regarding life and death, matters of law, because the Constitution dictates that one shall only be deprived of life by a decision of a court of law. So my submission is that by removing that function and causing you to make reference to a body which is not here to hear the evidence, determined to see the demeanor, to see the veracity of evidence, is to undermine the impartiality. And to that extent, I will add that while my land colleague gracefully and passionately and professionally referred to what was told by Mr. Kizza, I am alive to the fact that he did not teach him that one. But it's over time, so perhaps there is a slip of mind. Mr. Chairman, the other one was in regard to the MOU. Mr. Lupago, counsel, my senior colleague, did refer the fact that we have not seen the MOU. It is not, even where we don't have a hard copy, perhaps counsel should have been gracious to say it is dated today, it was signed here, and signed by these people. Because the Constitution, Mr. Chairman, in Article 123, reads, the President or a person authorized by the President may make treaties, conventions, agreements, and other arrangements between Uganda and any other country, or between Uganda and any other international organization or body in respect to any matter. The second article is that Parliament shall make laws to govern ratification of treaties, conventions, agreements, and other arrangements made under Clause 1. It means that an agreement, which would be an MOU, which has not been ratified, cannot be or operate as a law, as our colleague tried to point out. It was therefore, my Lord, Mr. Chairman, Section 4 of the Treaty of the Act Repealing the Ratification of Treaties says that all treaties ratified by Cabinet shall be laid before Parliament as soon as possible. So to the extent that the procedure commanded by the Constitution was followed, our colleague shouldn't have been referring to an MOU. They should have been referring to an act which was made before Parliament, which arose from a ratified MOU. So to the extent that we are looking at an agreement, Mr. Chairman, I don't want to assume that my colleague would agree that as it happened to the accused persons, A2 and A3, that if that fate befell him in the General Court Martial in Kakamega in Nairobi, he would argue that I am here properly because of an MOU I haven't seen. So we request that, again, the right thing is done. We cannot base on an argument to determine rights and movement of people. As Article 123 commands, lastly, Mr. Chairman, is the prosecution team, heavily led by Colonel Raphael, did, in their view, read the questions we proposed and the provisions of the law, and in their view, found that there was nothing to interpret. Mr. Chairman, the point we are making is that the interpretation we are seeking is not the meaning of the words in the statute. That's not the interpretation under Article 137, 5b. The spirit of that article is that it envisages a state of affairs, such as now, which could be an act as action or a law, but which must be put into perspective or juxtaposed with the supreme law, which is the Constitution, to see if it complies with the basic requirements in the Constitution. So it is correct that when we read those sections, we understand what they say. We are only saying that to the extent that we understand them the same way as they do, those should be brought within the perspective of the Constitution to determine whether they will contravene the rights of the accused persons. It's not the ordinary meaning. So we do request. And I have seen, Mr. Chairman, that our colleagues do not quite disagree with the way those questions were framed. As my colleagues have said, that is what was expected. That's what the way envisages. As my colleague read the rules, that once the questions have been raised, the role of the court is to frame those issues and forward them in the manner provided by the Annex Chapter. 8 copies. To the extent that they don't disagree with the issues as framed, our request is that the necessary result should follow, that the questions as framed, which they appreciate, be forwarded to the higher court for interpretation, just so that when we come here, we don't bog this court down with objections, because then everything shall be in the clear perspective. We thank you for listening to us.
To rule on all issues raised in the